Now let's talk about the prohibited powers of the legislators. Prohibited powers. The government cannot enact retroactive criminal statutes. These are two very important concepts. The government cannot enact retroactive criminal statutes or deny defendants a trial or the right to have a trial. These rules were in place, common law, way back England times, Parliament, early colonial times in America. These concepts called Bill of Attainder and ex post facto laws. Founding fathers took charge of those when they created the Constitution. A Bill of Attainder is it's an act by a legislator declaring a person or group of persons guilty of some crime and punishing them, often without a trial. So if they determine that somebody committed some crime, boom, they impose some sort of penalty without some sort of adjudication or a trial. Bill of Attainder. And those were used, like I said, back by the Parliament, and they kind of fell out of disfavor. And you'll see when in the next slide, we'll talk about how they came about in the Constitution. But just define these real quick. An ex post facto laws punishes individuals retroactively. What do I mean by that? They impose a law after the fact. So let's kind of go through these a little bit. So what did the Founding Fathers do with regards to these? In the Constitution of the United States, Article 1, Section 9, Paragraph 3, provides that, this is expressed language, in quotes, no Bill of Attainder or ex post facto laws will be passed. So any laws that do these two things will be deemed unconstitutional. So no retroactive criminal statutes unless it's going to benefit the defendant. I'll talk about that in a moment. And a defendant cannot be denied a trial. Now, the Sixth Amendment also incorporates the fact that you're entitled to a jury trial, not just a trial, a jury trial. So I already kind of delved into the Bill of Attainder. The legislator cannot deny a person a trial or declare somebody guilty just because, without having some sort of due process, as they say. And we're going to talk about the due process statute. So ex post facto law punishes an individual retroactively. Why? Why not? Why can't they do this? Because it encroaches on what? Fairness, right? An ex post facto law would be saying legislators passing a law, let's say in 2020, for something you did in 2019. Right? It was perfectly legal in 2019. They pass a law in 2020, and then they say, oh, we're going to arrest you. No, right? It's not fair. So don't want to punish behavior before the law becomes into effect. And the other stretch of this is they can't increase the punishment for the offense after the crime occurred. So let's say that you commit a crime, and you are arrested for that crime, and you are found guilty of that crime. And let's say at that time the penalty was a year in the county jail. It was a misdemeanor, a year in the county jail. But 6 months after that conviction, the legislators say, you know what, that's going to be a felony. We're going to increase the punishment to prison. And then they give you a prison sentence. No, they can't retroactive apply a harsher penalty on you. Why? Fairness. It's all in fairness. All to put you on notice. So, changes to law, like I said, with regards to criminal statutes, if it benefits the defendant, it will operate retroactively. So, if it does not, it won't apply. So if you're looking at a statute or a law that comes into effect, and you have to see how they're applying it, are they applying it retroactively? If it does not benefit the defendant, it's probably going to be deemed unconstitutional, as post expo facto. Did I get all that? That's a tough one. Ex post facto. But if it is to the defendant's benefit, and a big example of this is the death penalty. So the state of California had the death penalty up until 1973 before they did away with the death penalty. So anyone who was on death row, like Charlie Manson at the time, who got a sentence to death, but once the legislator did away with the death penalty, he still wasn't on death row. It's life in prison without the opportunity of parole. So in that sense, the defendant was benefited. The same does not hold true if the law is overturned or deemed unconstitutional by a court. This retroactive does not apply. So let's say you are convicted of a crime right now, on today's date, the day you're watching this, on today's date, and next month, and you're sent to prison, and next month the Supreme Court deems that the statute that you are convicted under is deemed unconstitutional and tosses it out. That doesn't mean you're going to be released. It does not apply if a court overturns or deems it unconstitutional, because at the time, the law was the law. Of course, anyone with a case pending relative to that charge or future going won't be able to be convicted under that. So it only applies to the legislative laws, what legislators are doing. And also, this ex post facto law only applies to criminal laws. It won't apply in civil matters, which brings me to Smith versus Doe. This is a Supreme Court case reviewing a statute from the state of Alaska, their Megan's Law statute, which is the Sex Offender Registration Act, SORA for short. We're going to talk about that more when we talk about sex offenses. But under this statute, if you are convicted of a sexual offense in the state of Alaska, because that's what we're talking about here, when you are released, you have to report or register yourself with personal information with a law enforcement agency in the community. That's the general gist of it. We'll talk more about it later on this semester. So that act was passed. I don't remember exactly the year. It's not relevant, but it was passed. And in this instance with Smith versus Doe, please note that there are two individual names there, so that should flag you as, ooh, wait, this sounds like a civil case. It says Smith versus Doe, which is exactly what it is, and which is exactly what the Supreme Court said. So the argument the defendant made was, well, this violates the ex post facto rules. I wasn't put on notice that I had to register as a sex offender when I was convicted of my sex offense, and that's a violation of the Constitution. And the Supreme Court said, nope, that is not unconstitutional, and the reason why is because the law isn't punitive in nature. It's not taking anything away from you. It's not taking away your liberty. It's not putting you in jail. It's not doing anything to you except making you have to give your personal information to law enforcement, basically so they can know where you are. So that was a civil. They declared that a civil statute, and it was not, and it was deemed constitutional. And every state has one of these sex offender registration acts. This is also similar or analogy to the Department of Motor Vehicles when they pass more restricted rules relative to being licensed. When you have a conviction for a DWI, you may get a conviction for a DWI, this month, and 6 months down the road, the DMV decides that they're going to not give license to people who've had one. Like they could totally do that. So that is our ex post facto Bill of Attainder discussion. The other constitutional provisions I want to talk about in this video is the concept of due process. You may have heard that term before. And equal protection clauses. Now, most of the constitutional protections afforded to criminal defendants are found in the Bill of Rights, the first 10 amendments. And the Bill of Rights is codified inside the Constitution. But my question is the federal Constitution. My question is, does this only apply to the federal government? No, it doesn't. It applies to the states, the cities, and the locales. And here's how it does. After the Civil War, the 14th Amendment was added to the Constitution, which added that it included due process and equal protection, affording more protections that encompass the protections afforded in the Bill of Particulars, or the Bill of Rights, and it extends to our states and local governments as well. So it was the 14th Amendment. This introduced this concept of due process. What does due process mean? No person shall be deprived of life, liberty, or property without due process of law. So let me go through that again. No person shall be deprived of life, that's capital punishment, liberty, incarcerate you, or property, take away your property, or forfeiture. There's a criminal type proceeding that's called forfeiture, without due process of law. Fair treatment through the normal judicial system for citizens. That's our due process. The due process is giving fair treatment through normal judicial system to the citizens. And who's that? Well, anyone, and we'll use citizen lightly. Like I said, that's anyone who's on U.S. soil. So if there is an illegal immigrant here, and they've been charged with a crime, they're entitled to fair treatment in the judicial system, meaning they have their case being able to take you through the judicial system to make sure your rights are protected. The police can't just come and get you, declare you guilty, and stick you in jail. It protects individuals from unreasonable loss of their fundamental rights that are codified inside the Constitution. Normally, claims of due process or violation of due process comes as a defense in criminal cases. The defendant is bringing it up. They can bring it up right while the case is pending. More times than not, it's usually on appeal after they're found guilty. They challenge the due process or how they were treated in the judicial system. As well as, when I say in the judicial system, from the point of arrest all the way through the system, not just in the court system. It may be how they were treated by law enforcement from the beginning. All right, so key, the government violating your rights. Bill of Rights also has a procedure for these due process protections. Can't be punished without proper notice and an opportunity to be heard. Again, you can't be taken and put in jail. You're entitled to be notified of what you're being charged with. That's the arraignment process from the get-go. And giving you an opportunity to be heard. That's allowing you to challenge everything that has occurred, whether it might be a legal search and seizure or the not taking read your rights, or an interrogation has happened, all the way through trial. I'm innocent of these charges. People have to prove me guilty beyond a reasonable doubt. So these Bill of Rights that are found, Constitution, jury trial, defendant has the right to a jury trial. They have the right to remain silent. They have the right to counsel, right to be free of an illegal search and seizure, a right to a speedy trial, not to have a harsh or undue punishment, and what else did I miss? Right to remain silent. That means no, they have to get their Miranda warnings, and I believe I've covered them all that due process will cover. So that's where the challenges come from. Those are the types of challenges you get under a due process clause. So equal protection. Equal protection is also codified in the 14th Amendment that states, "Nor shall any state deny to any person within its jurisdiction the equal protection of the laws." So this applies to the states as well as the federal government. The Fifth Amendment is the companion, is the equal protection companion of the Constitution. And what's its purpose? To prevent states from enacting criminal laws that discriminate in an unreasonable and unjustified manner. These are laws that basically target a class of people for special treatment, based on race, sex, national origin, disability, etc. Those are not going to hold up. So here's an example. The police officer, there's a law that says women can't wear a bathing suit in public, which actually was a law at some point. But do you see a problem with this? Does this violate constitutional right? Yes, it does. It's based on gender. And so a man can wear a bathing suit in public, but not a woman. So this would be something that would not be constitutional. Again, laws have to be rational and have a legitimate government interest. So let's talk about that Sex Registration Act that was deemed constitutional. It's based on felons. They're getting more punishment. Is that deemed unconstitutional? No, we just talked about that. And the reason being, because there's number one, a legitimate government interest is to protect children and put the public on notice that this particular individual has a conviction for a sex offense. So in that instance, it's not punitive in nature. So it's not really targeting a class under equal protection, even though the defendant would argue the class of people who have those convictions, but it doesn't really fall under the realm of this constitutional right. What about a local ordinance that makes it a misdemeanor to dress in quote-unquote gang attire? You think that would be constitutional? Or is this targeting a certain class, or is this something completely different? Well, my first question would probably be, what do you mean by gang attire? Right? This goes back to that video example. And who actually dresses in gang attire? Are we, is it a group of kids that hang out on the street corner? Is that like, who determines what gang is and who determines what gang attire is? And what if it's Halloween? Or what if you're on your way to a play and that's your costume? This is an example of a statute that might be unconstitutional under both equal protection and void for vagueness. So the Equal Protection Clause, just to kind of recap, is going to protect individuals from being targeted because they are in a special class. Okay? Like my gender example, that's a really straightforward example. Due process is fairness to the judicial proceeding, and that you are entitled to that judicial proceeding when you are charged with a criminal offense. So this concludes this part 2 of our Constitution discussion. We are going to jump into the next video. Is going to be all about the laws, criminal laws affecting the right to free speech, and followed by that, we'll talk about the other constitutional clauses as well.